Good afternoon, everyone. Welcome to the third ASEM Forum on Human Rights of Older Persons. My name is Yi-Jong and I will be your host for today's event. First of all, thank you so much for taking the time out of your busy schedules, and it's a great honor to be here as the host for this meaningful event. Today is the second day of this forum, and like yesterday, in-depth discussions will be carried out. I hope we can find the great ways to solve the problems that we are facing right now in terms of the human rights of senior citizens and aging population. All right, now we'll begin the third session of this forum. The main theme of this session is dying with dignity, debates and policy responses. Yesterday, we focused on aging in place, but today we're going a little bit more straightforward. All right, there will be 5 presentations followed by a panel discussion. Dr. Younsuch from Ulsan University will be our moderator, and I'm going to introduce our speakers and debaters. Professor Derya Kaycan from Turkish-German University is with us online. And Dr. Angelika Raihestein from University of East Anglia is with us online. And Professor Atsushi Asai from Tohoku University is with us online. And we have Professor Yi-Jong from Seoul University. All right, could you come forward to the stage? Please welcome them with a big hand. 네, 자장님 그리고
We would like to invite our moderator and speakers to the stage. Professor Seo, would you like to join us on stage, please?
이번 세션에서는 총
For this session, we have a total of 4 presentations followed by a discussion. I would now like to turn the floor to our moderator.
Thank you. Good afternoon, everyone. Welcome to session 3 on dying with dignity. As introduced, I'm Dr. Younsuch working at Asai Medical Center. We have 4 distinguished speakers on this session. Because we can run 2.5 hours, each speaker will have a 25-minute of presentation and 5 minutes of discussion with the audience. The audience can ask a question during a presentation by clicking raise hand button in the screen. Let me invite the first speaker, Dr. Deryanu Kaycan at Turkish-German University. He will talk on the right to die with dignity, a European perspective. Please.
Hello, thank you very much for the invitation. My name is Deryanu Kaycan, and I am working at the Turkish-German University. And before that, I did my master's and my PhD in Germany. I will share you my slides. Okay. Well, so today I'm going to talk to you about the right to die with dignity from a European perspective. I will start my presentation by first giving a short definition of the right to die and the terminology that we use. Afterward, I will briefly mention the permissive states within Europe, meaning those which in one way or another allow the practice of the right to die. I will then focus on 2, let's say, pioneer states in the right to die field, namely Switzerland and the Netherlands. A comparative analysis of these 2 states, I believe, will portray 2 different approaches to the right to die. And surely being the European perspective, I will then talk about the right to die under the European Convention of Human Rights and briefly on European Union law. I will finish my presentation with lessons that I have extracted from the permissive European states for all other countries that might consider allowing the practice of the right to die. So First of all, I would like to describe what we mean by the right to die. Namely, right to die is the right to choose the time and manner of one's own death, is respecting someone's autonomous and explicit request to end their own life. And within this context, what we define euthanasia as is the act of terminating the life of a person upon that person's explicit and autonomous request. And assisted suicide is described as ending one's own life with the help of another person. Now, I wanted to go into the different categorizations that exist in the literature of euthanasia, active, passive, and based on voluntariness and voluntary euthanasia and so on. But due to our time, and I really want to talk more about the comparative analysis and focus on that, I will skip this part. And if there are any questions, then I will come more in detail why I believe these categorizations are not necessary anymore. But for the context of this presentation, euthanasia is the act of terminating the life of a person upon that person's explicit and autonomous request, meaning it is based on personal autonomy. Now, in Europe, assisted dying is practiced one way or another in these countries. It's the first and foremost is Switzerland, namely very famous for their suicide organizations. They have been practicing assisted suicide since 1990 without a legal framework. The first state in Europe to make a legislation on euthanasia is the Netherlands in 2002, which was shortly followed by Belgium, and then in 2009 by Luxembourg. The United Kingdom, assisted suicide and euthanasia are illegal. However, there is a policy on prosecution that is slightly more lenient for those who assist their family members or their friends to, for example, Switzerland, where they can receive suicide assistance. Italy, Germany, and Austria, all of these states' constitutional courts have given favorable decisions on the right to die. Only Austrian parliament has followed this court decision with legislation that allows assisted suicide. However, the Italian and German parliaments have been slow and they have not yet adopted a legislation. Euthanasia and assisted suicide is also now legal in Spain and Portugal. In this presentation, I want to focus on Switzerland and Netherlands because these are the two states where there has been the longest practice and where there is simply two very different approaches to the right to die, which I believe is very interesting. Switzerland, the Swiss practice of assisted suicide, where euthanasia is illegal, it is only assisted suicide, is based on the notion of personal autonomy. The patient's, the person's wish to end their own life was the main focus when this whole practice developed. As you all know, Switzerland is very famous for their assisted suicide organizations. You might have heard of Dignitas, of Exit, and for example, Dignitas and several other organizations also provide suicide assistance to foreigners, which have also somehow introduced the concepts of suicide tourism or death tourism into our vocabulary. Dignitas has almost members from almost 100 different countries, and also from South Korea, 117 members, and there have been 4 cases of assisted suicide from these members. Being so international and attracting so much international attention, one might think that this practice has a very solid legal framework. However, the whole Swiss practice of assisted suicide is built on a gap in the criminal code. There is no legal framework. The criminal code does not criminalize suicide, and it only criminalizes suicide assistance if it is done out of selfish motives, which means a person who is assisting suicide without any selfish motives, just to help, they will not be punished. So based on this gap, the omission of the criminal code, assisted suicide organizations, which function as nonprofit organizations, have developed. They started their first activities and practices in 1990, and since then, the whole practice of assisted suicide in Switzerland has developed. It has developed mainly through the practice of these organizations and through customs. However, on the other side, Netherlands, while personal autonomy was in the focus of the Dutch practice as well, it was basically and mainly the doctor-patient relationship, meaning that it was the doctor's sense of responsibility and the sense of duty towards their patient to relieve their patient's pain, to respect their patient's wishes, that created and developed the practice that it is today. And also it was the physician's sense of duty, which they then practiced euthanasia or assisted suicide, and that followed with a very rich case law, and with the cooperation with the medical profession and also the case law, the courts, they had already started to develop a guideline of how the practice would look. So when the legal framework was adopted in 2002, this was basically catching up with the reality of the Dutch practice. There is a very comprehensive legal framework, and the medical profession also is very up to date with the practice and always publishes guidelines or opinions or reports, very detailed to guide the physicians who practice euthanasia and assisted suicide. This is totally opposite in Switzerland. There's almost no guidelines. The medical association has not commented on assisted suicide even until 2004, almost 14 years. Assisted suicide had already been practiced, and as you know, assisted suicide is practiced by prescribing sodium pentobarbital, which is bound to prescription. A physician has to prescribe it. So there have been physicians who were prescribing sodium pentobarbital for assisted suicide. However, the medical profession had not commented on it for 14 years. And in 2004, when they did comment, they did not actually accept assisted suicide as part of the medical profession, but they did briefly mention how a physician could feel compelled to prescribe. When they did more in detail comments on assisted suicide and tried to adopt some requirements, this has divided the medical profession in Switzerland very deeply. The medical association was divided into two, and there have been so much discussion in this regard. What we see as a very big difference between the two states is in Switzerland, the assisted suicide practice has been, the medical profession has been trying to stay far away from it. But in the Netherlands, the medical profession really embraced the practice, and they've been the ones who really led the way to its legalization. The requirements in both states is in Switzerland, it's the patient has to have decision-making capacity, and the person assisting with the suicide must act with non-selfish motives. In Switzerland, there must be a voluntary and carefully considered request, a decision-making capacity. The patient must be suffering from unbearable suffering with no prospect of improvement. The patient must be well informed about the situation. There must be no reasonable alternative for the patient. And there must be also a consultation with an independent physician. And the whole process of euthanasia or assisted suicide must be completed in due medical care and attention. What we see here is also, I must add, unbearable suffering with no prospect of improvement is what is unbearable suffering, the patient decides. It is up to the patient to define what is unbearable to them. And it is also up to the patient to define and decide what is a reasonable alternative, or is there any. So basically, the criteria is very subjective as well when it comes down to it, and it is the patient that decides how it will be. Now, yes, I will then continue. Sorry. With the European Court of Human Rights, European Convention on Human Rights. So all the states that I have mentioned, they are also members of the European Court of Human Rights, and they also must follow the criteria set out by the court. The European Court of Human Rights did not have many cases on the right to die, but a study of the few cases so far that there was has shown that the court accepts the existence of the right to die as an aspect of personal autonomy under the right to private life, and balances this right against the right to life. The personal autonomy that is expressed in the form of the decision to end one's own life must be balanced against the state's positive obligation under the right to life, namely to protect the life of those who are vulnerable and need protection. Now the question is, how do we achieve this balance? And does the respect for personal autonomy outweigh the state's obligation to protect life? And if yes, to what extent? The court has restricted itself to more of a procedural approach. This means the court gave the balancing formula, but it left it to the member states to decide how this formula will apply. This is the court's general solution for topics that include highly sensitive ethical concerns, and when there is no consensus among the member states. The court gives an especially wide margin of appreciation to states when dealing with such subjects, when there is no overwhelming consensus between the member states. As long as a member state observes their obligation to protect life and respect personal autonomy, the way they do this, the way they balance the two, lies within their own discretion when it comes to the right to die. Apart from Switzerland and now the United Kingdom, the rest of the states are also members of the European Union. Under EU law, healthcare is an area where member states have not transferred their powers to the European Union. This means healthcare is within the member states' own responsibility. And there are 27 members of the EU, and only 6 allow assisted dying, while 2 other states have been favorable, but not yet have a legislation. This means there is no consensus, and the subject is highly controversial also. Under EU law, however, EU citizens enjoy free movement rights. One of those rights is the freedom to receive services under Article 56 of the Treaty on the Functioning of the EU, which includes also healthcare services. In addition, Article 7 of the Charter of Fundamental Rights of the EU protects the right to private and family life. And the interpretation of this article is parallel to the corresponding article under the ECHR, Article 8. So the fundamental freedoms of the EU, including the freedom to receive services, must be interpreted in line with fundamental rights. This means that no one can stop a person who is living in, let's say, France, where assisted suicide is not legal. If they want to travel to the Netherlands, where they can receive euthanasia or assisted suicide, and no one can stop them. It is within their own right. However, the issue lies when not everyone who is wanting to end their life are able to just simply get up and leave and cross the border. Some of these patients are very, very sick and they cannot travel on their own and they need assistance. So the main question is, what happens to the people who want to help the patient and who cannot travel on their own? What happens when they need the help of a third person? Because in most member states, helping someone to commit suicide is a crime. And it could be that the person helping the patient to travel to the Netherlands, or let's say Belgium, they might face prosecution when they come back to their country. So far, there hasn't been a case like this. There have been some cases in the UK, but they were mainly some people who helped their loved ones or family members travel to Switzerland for assisted suicide when they faced prosecution. They claimed this was in contradiction with the ECHR, but there hasn't been a case where someone traveled to another European Union member state while UK was in the EU and claimed that their freedom of movement or freedom to receive services were violated. So we do not have an example how the European Court of Justice would interpret, or any member state would interpret this within the context. But I think if the patient is unable to travel on their own, punishing the person who is helping them would restrict the fundamental freedom to receive services, and it would also then violate Article 7 of the Charter, the right to privacy. And in this case, the proportionality of the restriction has to be explained by the member state, and the member state has to justify. But just like with the European Court of Human Rights, I believe also the ECJ, if there were such a case, would also give a very wide margin of appreciation somehow, would be very careful of commenting and saying something very definitive on the subject. This question was actually asked to the commission, I believe, or the court, and they did not make any comment because this was a subject that was within the power of the member states. Now, the lessons for others. These are the lessons that I have extracted from the analysis of all these states, and I believe these are the most important ones for any country who is thinking about legalizing this assisted suicide or euthanasia. They should take these into consideration. First of all, we see that there should be a very clear and there should be clear and sufficient procedural guidelines, because in Switzerland, as I said, there is no legal framework, and the whole practice where also internationally many people travel to commit suicide to end their lives. There is no legal framework, not sufficient guidelines for the physicians, and the guidelines that do exist, they are not legally non-binding. And without clear and sufficient procedural guidelines, it's a very big risk to take, and it would also mean, as I said, under the European Convention of Human Rights, under right to life, the states have the obligation to protect life, and without sufficient guidelines, without a legal framework, I do not see how a state would be fulfilling their obligation to protect life and preventing risk of abuse when there is such a practice. The second one would be definitely a psychiatric consultation. Any patient who is wishing to end their life, they should see a psychiatrist. Whether their decision-making capacity should be established. This is highly important also. Even if the patient is not suffering from any psychiatric illness, I believe there should still be a psychiatric consultation because the whole concept of the right to die is based on personal autonomy, and we have to establish that this wish is solely based on the autonomous wish of the patient. And there should be a palliative filter. Any state who is wishing to practice assisted suicide or euthanasia must make sure that their palliative care system is up to date, it's functioning well, because sometimes, more often than not, patients decide not to go through with euthanasia or assisted suicide once they receive proper palliative care. Fourth, there should be an effective and transparent supervisory system which provides a control mechanism of how this practice is ongoing. And then there should be a support for healthcare personnel. The Netherlands really provides very good support for their healthcare personnel, professionals. They also provide consultation. There is an institution that provides consultation to physicians who want to carry out euthanasia. But there should also be psychological help for healthcare professionals who participate in the process. And 6, there should be constant research, and we should keep statistics, especially looking at Switzerland and the Netherlands and Belgium also. We have to see, because one of the main worries of the right to die and assisted suicide or euthanasia is the argument of slippery slope. So we start from point A, but over time, do we extend the practice? Would it get out of control? I did not go much into detail about this, but the practice in the Netherlands, and especially in Belgium, I might say, the practice has not stayed within the limits when the legislation was first adopted. Over time, through interpretation, or they caught up with the reality of the practice that was not being outspoken, the limits of the practice have expanded. While it was first only for terminal patients with terminal illness, then it was for patients with unbearable suffering. Then unbearable suffering is also very subjective. So what do we consider unbearable suffering? Do we also include psychiatric illnesses as well? And then do we also include simply someone who is, done with life? They are satisfied, they are fine, and they just want to end it now. Where does it end? We should keep statistics and see, and also take lessons from those statistics as well. And the last one is the rights of everyone involved in the process should be observed. This includes the patient far and foremost, the doctors, the physicians, the nurses, anyone from the healthcare team that is involved or who does not want to be involved, and also family members. Everyone's rights should be observed in this case, and this is also a very delicate balance to seek out. And I will end my presentation now because I think I've reached time. Before I finish, I would quickly like to mention something I think the moderator is already aware of. I have to catch a plane for a business trip in a few hours, and living in Istanbul, there's a lot of traffic, so I might need to leave a little bit early. But I will connect to connect over my phone again, and as long as I'm in the mercy of the reception, but as long as I have connection, I will follow through the end. I just wanted to let everyone know, so you already know. So thank you very much for listening to me, and if you have any questions, I'm free, and if I cannot answer your questions, please email me, and I will be more than happy to answer you. Thank you.
Thank you, Dr. Kaycan, for your informative lecture introducing the definition of euthanasia and history and current situation of assisted dying and voluntary active euthanasia in European country, including your recommendation to enhance the better assisted dying in globally. So now open for questions or comment from the audience or other speakers. Dr. Kaycan, while waiting questions from floor, I would like to have a question. As you know, when we discuss about death with dignity with various members of society, the members' different understanding of relevant terms frequently become a major stumbling block. This is especially, I think, true in terms of euthanasia and death with dignity. So what do you think about limiting the definition of euthanasia only to voluntary active euthanasia and physician-assisted deaths to clarify the public's understanding of euthanasia? What do you think?
I believe this is absolutely necessary because especially euthanasia is also used as a synonym for withdrawal of treatment and withdrawal of life-saving treatment, or prescribing medication, increasing doses of pain medication until death is inevitable, or let's say palliative sedation. I believe the meaning should be separated because the right to die, how we talk about personal autonomy, the concept of euthanasia is different. The basics of how we justify or try to justify euthanasia, voluntary active euthanasia, and then withdrawal of treatment are separate. Withdrawal of treatment is usually, if the patient is conscious, is based on the right to refuse treatment of the patient, and or if the patient is unconscious and doesn't have the decision-making capacity, it's usually a determination of the best interest of the patient, medical futility or medical interest of the patient. So the basis of each argument is I believe it's separate. It should be separated. They are still very much withdrawal of treatment or pain medication. They take a large part of end-of-life decisions, and they're highly important and must be discussed because there's still a lot of confusion on that regard also. But in order to have a healthy and fruitful debate without any confusion, it is highly important to differentiate. I can give one example. Whenever I try to research something from France and I write assisted dying, what I always come across is withdrawal of treatment, cessation of treatment, life-saving treatment. This is very confusing because then I see there is some positive developments or in favor developments on that subject, which is then reflected as France is accepting assisted dying. This causes some confusion. So as I said, to have a healthy debate, a healthy discussion on the matter, I believe these concepts should be defined clearly, and from there on we can proceed to have a fruitful, productive discussion.
Thank you. Please.
Hello. Hello, I'm Younsuch from ASEM Global Aging Center. Thank you, Dr. Kaycan, for your interesting presentation. So we learned a lot about the practice or legal framework at the European Union level. So you introduced us different cases in European Union countries, European member states. But I just wonder, although the many countries are actually adopted a different approach to euthanasia, but I just wonder whether there is a kind of convergence movement towards one direction at European level, although at the moment, many countries have different approaches. So I just wanted to see the prospect or the movement towards particular direction in particular topic area. Thank you.
Okay, so as I said, under the European Convention of Human Rights, there is only a few, and within the European Union, let's talk from European Union, 27 member states, and there's only 6 of them who, one way or another, they practice euthanasia or assisted suicide, and there are 2 others who their constitutional court has given a favorable decision, but the legislation is not following as of yet, because for Germany, I can say, because the legislation does not agree with the court's decision, so they are dragging their feet. But for Italy, I do not know yet why the parliament is also very slow. But there's certainly increasing debate on this, but I do not see anytime soon that there will be a consensus on the subject. The opinion on the right to die, euthanasia, and assisted suicide, when we analyze and examine the countries who allow the practice right now, we see that the cultural formation of the country, the society, the religious background, there are a lot of factors that come into it. And while some have been already discussing this since the 70s, since the 80s, there are still some where the right to refuse treatment when the patient is conscious and does not want treatment, this is still a problem. So there are still many steps to take, and there's still a long way to come to a consensus, but I don't think there will be in anytime soon.
Thank you, Dr. Kaycan, to join under your busy schedule. Do you like question? Oh, yes, please. Do you use the microphone?
European view and European legal guideline. But my question is with the historical experience of Nazi public health for euthanasia, which was initiated by government. Yes, naturally there is the which influence came to a European view and European guideline came from the historical notorious experience of Nazi monsters. There's in East Asian context, or naturally in Korea, there are no experience like that. But this in last year, the Japanese movie of Hayakawa Chia's Plan 75, yes, the famous in the international, which yes, ignited the government initiated the assisted death and euthanasia. So how do you think about the influence of Nazi experience of euthanasia in two European view and European guideline?
Thank you very much for the question. I can give an example. I talked about the Netherlands and their historical background, and I said the practice of euthanasia and assisted suicide and how it come to be legalized was based on the patient doctor-patient relationship. How this came to be was actually during the Nazi period. When the Nazi regime took over, they executed several physicians in the Netherlands who were refusing to give up their list of patients. So a lot of physicians in the Netherlands during the Nazi regime died protecting the privacy of their patients. This is actually one of the reasons why there is such a strong bond between the doctor and the patient in the Netherlands, and why patients feel that they trust their doctors, and why doctors feel more sense of responsibility towards their patients maybe than from other countries. And another thing is, when you look at Netherlands, over 80% of the euthanasia cases or assisted suicide cases is practiced by the general practitioner, the house, how you call that in English, the general practitioner of the patient. So everyone has a doctor, family doctor is the correct term. Euthanasia is practiced by family doctors 80% of the time. But let's look at Switzerland. This is not the case. The doctor who is prescribing the medication for assisted suicide has maybe once or twice met with the patient, but they do not have any relationship. The history that is based in during the Nazi regime affected how Netherlands look at doctor-patient relationship in this way. Let's come to Germany. the term euthanasia is not used in German. The term is, let's say, strictly off limits. And also in Germany, we never discuss euthanasia. It's always assisted suicide. And we talk, then we translate that to Sterbehilfe, help to die, assistance to die. But we never talk about euthanasia. You cannot see it in the literature. So that is the difference. The terminology, that's why we always say the terminology matters a lot. In let's say in Spain, maybe in UK, maybe, or in Turkey, when we say euthanasia, we do not feel very frightened because we did not go through that period that much. And euthanasia is more of a neutral term for us. But depending on the experience of the countries, euthanasia is sometimes scarier, and then it causes also a blurry, it disturbs the discussion of the right to die as well. So some authors also suggest to use assisted dying, no euthanasia, just assisted dying, or termination of life, how the Netherlands describes it as such in their act. But no euthanasia. So terminology is very important. We have to clarify that. And it certainly, historical experiences affect how we look at the discussion as well.
Thank you, Dr. Kaycan. Whenever we talk about this, there's lots of debate is always there. We are already behind the time. Let me move on next presentation. The next speaker is Dr. Angelika Reichestein at University of Iasa, Anglia in UK. She will talk on dying in dignity in England and German, enhancing a good death, please.
Thank you very much. Thank you for inviting me to participate in this fascinating forum. As I was just introduced, my name is Dr. Angelika Reichestein. I am originally from Germany, but I live and work in England, where I did my LLM and my PhD in human rights law. While I teach criminal law and constitutional law, my research is very much about human rights law, the right to life, and implications on death. So today, let me share my screen with you. Today, I would like to talk to you about how we can enhance a good death in England and Germany. And luckily, I decided to not speak about the same subject as Derya did just now. Instead, I want to focus on the place of death. So what I will go through
would you share the screen, your slide?
I'm sorry, I'm sharing the wrong thing then. Let's see what else I can. Here we go. Can you see my screen now?
Yeah, thank you.
Wonderful. So first of all, I will give you some death statistics about England and Germany. We will briefly look at legal regulations regarding a good death. I will then very briefly, because it has been touched upon already, look at whether there's a right to a good death under human rights law, before coming to the hospice movement and some ethical considerations. Now, in both countries, England and Germany, generally debates about a good death focus on assisted dying and euthanasia. We don't really debate the natural death and whether that is happening in a good way. So this is what I want to look at today by focusing on the place of death. And generally, as an underlying definition, a good death is seen to be a self-determined death, a death that follows the individual's wishes on how to die. So some statistics. These numbers are from 2021. In the first column, you can see the general population of England and Germany. In the middle column, the percentage of the population that has died, which is roughly 1% each. And then in the last column, the most important one for this presentation, the number of deaths in hospital. So in England, about 70% of all deaths of 2021 have occurred in a hospital setting. In Germany, in contrast, only about 44% of deaths have occurred in a hospital. Now, please don't worry about what the next slides look like. I will talk to you about the most important details of those. On this slide, we can see the place of death in England from 2004 until 2016 and the percentages of people having died in those places. The top line shows us deaths in hospital. So most individuals, as was seen on the previous slide, die within a hospital setting. It has slightly decreased, and what has increased are the two lines below. The dark red are those who have died at home. The yellow line signifies individuals dying in a care home setting. So both numbers are roughly between 20 and 25% by the year 2016. Death in hospice is consistently only at 5%. Now, in case anyone in the room or online is not aware about hospices, I will say more about them later on. Just briefly now, a hospice is an institution that focuses on palliative care. So at the very late stage of life, when the dying process has already started, a hospice will provide the kind of care to ease death. So usually individuals will enter the hospice at the end of a terminal illness like cancer. But to take away from this, in England, most individuals die within a hospital setting. Now, an even worse looking slide, apologies, but just bear with me, I will tell you the most important things about it. These are death statistics for Germany. They are telling us statistics for 3 different years. So they're a snapshot in time, 2001, 2011, and 2017. On the left side, we have death statistics for men, on the right for women. I will for now just focus on the left side and be brief about it. What we can see here in dark red is the percentage of individuals dying in a hospital. Generally speaking, that is around 50%, 50-60% for adults. For children or individuals under 18, it is even higher. It is between 80 and 90% dying in a hospital. The blue at the top is the percentage of those dying at home, which is between 10% for those under the age of 18, up to 20% or 30% for adults. Now, not surprisingly, with increasing age, the percentage of those dying in a care home increases. So towards the right of the graphic, we can see the beige indicator growing. That is the percentage of those dying in a care home. Very, very small is the number of those dying in a hospice setting. That is the darker beige above the light beige. Now, why am I boring you with these statistics? Because they do not represent where people actually want to die. There are studies in both England and Germany that investigate where people actually wish to die. And a large majority wishes to die at home. They wish to die in a familiar setting. However, very few individuals actually die at home. On this statistic, it is the blue colored percentage. So why then do we not have provisions in place that enable people to die a good death, a self-determined death, in the place they want to die? Let us now briefly look at some legal regulations. In England, the main legal provisions about healthcare are on this slide. Now, at this point, I would like to stress that England is, of course, a common law jurisdiction. So we have our regulations in both statutory law and in case law. Our main healthcare regulations are in statutory law. The Health and Social Care Act makes provisions about public health, about regulating health and adult social care services, and regulating the conduct of health and social care workers. The Care Act of 2014 is a law relating to the care and support of adults. It has provisions about safeguarding adults from abuse and neglect, and provisions about care standards. And the Health Care Act updates the law on health and social care. None of these entail any provisions on death or dying. And we can contrast that with the legal landscape in Germany, where we have specific laws on dying, on care at the end of life. We have the Sozialgesetzbücher, the laws on social matters. And 4 of those, the book 5, 9, 11, and 12, are specific to care and end-of-life care. The Pflegestärkungsgesetz is a law to support care provisions. Again, we have 3 different law books there. And most importantly for this subject, there's a hospice and palliative law. This is to enhance the spread of palliative and hospice care, to improve care, be that medical, psychological, or spiritual, in the last moments of life. So just to recap at this point, in England and Germany, the majority of people in studies say they wish to die at home. However, the majority dies in a hospital setting. In England, we don't have any law regulating a good death, whereas in Germany, there are attempts at making provisions for the care at the end of life. So briefly, touching on the question of whether we can have a right to a good death. As was already mentioned in the previous talk, we all have, under the European Convention on Human Rights, so as citizens in England and Germany, we have the right to life. Everyone's right to life shall be protected by law. So the state is under a positive obligation to protect our lives. Now, this is very important in any debate about death, because it curtails the right to a self-determined death, the right to a good death. This right is much more strongly protected under Article 8, the right to privacy, the right to respect for private and family life. And I will show you in a moment how the European Court of Human Rights has approached this when it comes to death. What is important to note is that the right to respect for private and family life under the European Convention on Human Rights is not absolute. The state can interfere with that right under the second paragraph of the right, if it is in accordance with the law, if it is necessary in a democratic society, in the interests of national security, public safety, the economic well-being of the country, or for the prevention of disorder or crime, or for the protection of health or morals. So there are many different strands under which the state can curtail the right to private and family life. So as was already mentioned in the previous presentation, we have this conflict. We have this conflict between the protection of life through the state, which curtails a self-determined death, and the right to choose elements of our life, including how we wish to die, under the right to respect for private life. Now, how has the European Court of Human Rights approached this? As has been mentioned, there have been very few cases where the European Court of Human Rights had to engage with the idea of a good death. They are generally assisted dying cases. In the first big case on assisted dying, Pretty and the United Kingdom in 2002, the European Court of Human Rights has been very clear that Article 2 cannot be interpreted as conferring the diametrically opposite right, namely a right to die, nor can it create a right to self-determination in the sense of conferring on an individual the entitlement to choose death rather than life. So the court has been very clear that the right to life means that life has to be protected. And it's not a coin with two sides where we also have a right to die. It only focuses on protecting life. But then we have Article 8 coming into the mix. And here we have an important case, that of Haas and Switzerland of 2007, which is also an assisted dying case. And here the court stresses that an individual's right to decide by what means and at what point his or her life will end, provided he or she is capable of freely reaching a decision on this question and acting in consequence, is one of the aspects of the right to respect for private life within the meaning of Article 8 of the Convention. So while Article 2 protects life, Article 8 gives us the freedom to make decisions about this, about how we wish to die, when or where. So we now have this conflict. Apologies for moving on when I'm not ready to move on. So Article 8 gives us the freedom to decide. Article 2 means the state has to protect our lives. The states under the European Convention on Human Rights therefore have to find their own balance in how to provide individuals with the freedom to choose a good death. Now, as I said, I'm not focusing on assisted dying. I'm looking at whether we're free to choose where to die and why so many people don't die where they wish to die. And important for that is to talk about the hospice movement, the idea of a hospice. Now, the hospice movement is relatively young. The hospice movement started in London in 1967, and from there it spread through other countries. It also went across the borders of Europe, and in the 80s it reached Germany. In both countries, England and Germany, we have over 200 hospices for adults, and we also have hospices specializing in hospice care for children. However, while this might look like a lot of hospices, the reality is very grim, so to speak. Individuals have to enter a waiting list to get a place in a hospice. So at the end of a terminal illness, they have to ask to be transferred to a hospice, and then they have to hope that a bed will become available. Now, the hospice, to repeat what I've said earlier, is a place that specializes in palliative care, that specializes in making the last moments of life as good as possible. And yet many people who reach the point where the hospice would be a good place to receive that care are not able to enter into hospice because there are waiting lists, because there are not enough hospice beds available for those needing them. In addition to the hospices themselves, there are also palliative care wings in some hospitals, There are mobile hospice services coming to individuals in hospitals to provide the care. But generally speaking, there isn't enough palliative care available. There isn't enough space in hospices to enable a good death outside of hospital. Why does it matter? It of course matters under ethical considerations. In England, in Germany, we very much stress the dignity of the individual and the autonomy of the individual. Dignity is seen as a foundation of human rights and of basic rights. The German Constitutional Court, for example, stated in a press release in 2020 that the guarantee of human dignity encompasses in particular the protection of one's individuality, identity, and integrity. Inalienable human dignity accordingly requires that any human being be unconditionally recognized as an individual with personal autonomy. It is a basic value of human life, leading to the possession of specific rights. And autonomy, which we also stress very much in debates about medical care, but also about end-of-life care, means the freedom of choice. And we do try to acknowledge that in end-of-life debates through also legalizing advanced decisions, or rather anchoring them in the law. So giving individuals the right to lay down in writing how they wish to be treated, how they wish their dying moments to take place. But advanced decisions are also ripe with problems, which is the topic for potentially another discussion, but not right now. So, to conclude, in England and Germany, most deaths occur in a hospital setting. And of course, we can't take all deaths out of hospital. But studies show that most individuals would prefer dying at home or in a hospice. Based on autonomy and dignity, much more has to be done to enable a dignified death based on the individual's wishes. The problem is depressingly simple and straightforward. It is a lack of funding. In both countries under consideration here, the governments do not provide sufficient funding for care. So care in the broadest sense is underfunded in both countries, which means that also end-of-life care is horribly underfunded. So we cannot enhance palliative care, we cannot enhance the hospice movement without the funding from government. And that is where I will leave it for now. Thank you very much.
Thank you. Thank you, Dr. Reichestein. Your comment regarding the problem to enhance the dying with the dignity is a global problem. So now open for questions or comment from floor. Dr. Reichestein, while waiting questions, despite of absence of law regulation of a good death in UK, the UK is known as the country providing the best quality of dying in medical facilities. What do you think makes the UK so special?
Well, I would like to say that it is the wonderful humans in the UK. I honestly do not know. I think we do have a great healthcare service, which hopefully will stay public and free. The National Health Service, it has just celebrated 75 years the past week. I cannot answer that. I do not know why we're better than others. All I can say is we're not good enough.
How about the level of the education in about the deaths in your society?
We do not have much death education. Death is a topic that is not being discussed. it is something that the government and society shy away from. It is based on seeing it as a taboo. It goes against the sanctity of life. And while we're a secular country, we still see life as sacred, and so should not engage with anything that touches upon enhancing a death. And with it being a taboo, we of course also stand in the way of bringing about vital reform. So I've done quite a bit of research as well on assisted dying. And while Derya is of course right that we have this policy that people are not prosecuted if they help someone abroad to die, we are far from a legalization of assisted dying, because those debates in Parliament are shied away from, and the conflict between sanctity of life and giving people the freedom to decide about their own life is seen as such a complicated conflict that we'd rather not touch upon it. So we prefer not to talk about death. Generally in England, we try not to talk about complicated subjects that might upset people.
Please.
Hello, this is Long from Vietnam. I have some question about your presentation about death statistic. In advance, I'm sorry for my little knowledge about England, and also I just want to refer the case of Vietnam and other country. The first one, whether in your statistic you have seasonal adjusted statistic for death, because it's very important for some country. The number of deaths may be increased in some season. Like in the case of Vietnam, I'm not sure about the case of England, but nearly the New Year, sometimes people have like a very different action, so that they face a number of deaths, increase usually in the year. And the second one, I just want to know about the cost of death in England, because that's also important to see whether people die at home or in hospital or hospice. And last but not least, I think you already mentioned in the statistics that the cultural variable is very important, because like the case of ASEAN country, I'm sure that maybe more than 90% of people want to die at home. So sometimes, even they have serious problem in hospital, they really want to move, people to home, in order to wait for death, rather than, die at a hospital. So I would like to see whether, some kind of different in terms of, cultural value. Thank you.
Thank you very much. Those are great questions. Now, my statistics are the very general ones that take the year as a whole. There are more nuanced statistics that look at in which month how many people have died. However, we don't see specific spikes like you've mentioned, where more people die around the new year. We don't see that. So we don't really have a season of death, so to speak. It is much more spread throughout the year. The cost of care is a very important element. And generally, the cost of death, the cost of death tends to be more pronounced when dying at home. Because when you die in a hospital, your care and your death are covered by your national health insurance. The NHS will take care of it. If you die at home, a care service has to provide care. We have taken the care of individuals, of our family members, we've taken that out of the family. And generally it is outsourced to care specialists. Now, those cost money. And the state only provides very little money for care. So if you want to have good care at home, you will have to pay yourself. You have to pay individually for care. And that makes death at home much more expensive. So we have to rethink how we want to approach care. which brings it back to the need of funding. The state has to do a lot more to fund care for all stages of life where we have real shortcomings.
Is it okay? Thank you. Let me move on. Next presentation. Next speaker is Dr. Yi-Jong at Seoul National University in Korea. He will present on dying and death with dignity in Korea, debate and response, please.
Yeah, thank you for my presentation about the dying and death with dignity in Korea, in Korean case. I am sociologist with German PhD in Free University of Berlin. Yes, I am a sociologist. Normally it's focused on not the legal perspective, but on real situation of human rights, including the good death. I know the it is important that I had seen about the miserable situation of hospice patients at home in Turkish family in Germany. So the sociologist perspective very important for developing more relevant human rights guideline, including the good death and the right to die. So it's my presentation is on the case of Korea. Naturally, Korean society said the idea of dignified death has been a social and political issue for a long time during Joseon dynasties. However, in modern societies, it has become the center of the entirely new form of social and political controversies in 2000s. Yes, this the figure shows a internationally rapid of aging into super-aged societies, and over the super-aged society like Japanese societies in 2030. So part 2 is about policy-related outline of a social debate about dying and death with dignity. In 2008, there is a proposal of the Dignified Death Bill and the Natural Death Bill. In 2009, the rule by the Supreme Court regarding the case of Grandma Kim.
Dr. So, would you share the screen?
Oh,
Your slide?
yes.
Oh,
yes, I'm sorry. Yes, I'm sorry. In 2013, the release of the recommendation by the National Bioethics Committees. In 2015, the discussion in the National Assembly on bill of decision-making of life-sustaining treatment in the dying stage and bill of hospice and palliative care. In 2016, the passage of promulgation of this the new act on hospice and palliative care and decision-making of life-sustaining treatment in the dying stage. In 2018, the full implementation of this act. In 2022, the proposal of the revision of this act, newly permitting assisted suicide with dignity and the holding of public hearings. Yes, part 3 is about the legalization of the life-sustaining treatment decision-making and hospice care at the end of life and this debate. Korean society has a well-developed national health insurance system. Yes, allowing the easy access to health care for everyone to the extent. As Korea has the worldwide in the most hospital beds. Similar like the Japan. This well-developed healthcare system has a dark side. That is the 77% of all deaths occur in hospitals. The majority of elderly persons prefer to stay at home for their final days, but only 15% of deaths actually occurs there. Korean society has confronted with the societal question of whether most people facing death in the emergency rooms of hospitals died in dignified way, and social concern have been raised. Naturally, particularly after the Borame hospitals incident in 1997. In response to these issues, the idea of respecting the self-determination of patients at the end of life stage has been consistently raised since the year 2000. In 2008, Grandma Kim was hospitalized due to pneumonia and became a vegetative state. Grandma Kim's family required the discontinuation of futile life-sustaining treatment, but their request was not granted, leading them to file a lawsuit. It was emphasized finally by the Supreme Court that discontinuing or deferring futile life-sustaining treatment was in line with guaranteeing the constitutional right of citizens to pursue happiness, leading to recommendations for the legislation accompanied by social debate. Table 1.1, it shows the general old person's opinion on right of knowing their own terminal situation. More than 80% of old men want to inform me directly to them or their families. On the basis, naturally, the old man has most positive opinion about the life-sustaining treatment decision. First debate about the legislation revolved around the potential for abuse in end-of-life decision-making. Not only religious organizations, but also disability right groups strongly opposed end-of-life decisions, fearing that it could easily lead to abandonment of lives of disabilities and vulnerable persons. Therefore, Catholic and Protestant religious groups concerned about the possible misuse of end-of-life decisions led to the restriction of the legislation to patients at the dying process rather than those in terminal stage. The second issue was the activation of hospice services following end-of-life decisions. Amendment to Cancer Control Act in 2011 allowed the terminal cancer. Yes. Yes, the most positive opinion of the this act, and second issue was the activation of hospice service following the end-of-life decisions. But the limitation of end-of-life decisions to the dying process result in a contradiction where patients in the dying process were eligible for hospice care. This table has showed the total persons writing and adjustment the advanced care directives. Naturally, fast growing and naturally, even in period of Corona-19. So as the situation of the writing advanced care directives is by table 2, according to age and sex. So it's many.
Would you proceed to the slide?
Yes. In 2013, the number of persons aged 65 and plus writing and registering the advanced care directives is 1.5 billion, account for 77% of total persons. In December 1922, the number of old men writing advanced care directives amount to 1.2 million, as approximately 13.5% of total elderly population. Therefore, now is the 14% of entire old men have written and registered it this year. And table 3 shows the real decisions for life-sustaining treatment. The total is 290,000 persons. According to Act, the
would you proceed the slide?
Yes, I'm sorry. I'm sorry. Yes. Writing to yes. According to the legally, these decisions can be done at first with writing advanced care plan with the physician's communication. Second is according to already written and registered advanced care directives. 3 is providing the document of his intention with the approval of at least 2 family members. Last is agreement of the entire family members, even with no document. So yes, in our in situation, there's the 3 ways as in 1/3 and equally. In these decisions, debating issues as the influence of family members who still pose the risk of distorting the self-determination for dignified death. Dying without burden to others, including families, is culturally considered as an important characteristic of good death in Korean societies. Choosing a death in order not to burden family members significantly compromises self-determination for dignified death. For dignified death, it's crucial to establish a culture of promoting individual autonomy alongside with the socio-economic support to vulnerable persons. The third background pertains to the fact that during initial implementation of the system, due to the potential for conflict, life-sustaining treatment decisions are predominantly made within the high-level general potentials, hospitals. 61% of these decisions took place in high-level general hospital, yes, with an additional 35% occurring in general hospitals. It is noted that the 86% of life-sustaining treatment decisions are made with these general hospitals. Otherwise, care capitals exhibit a high rate of decision with a clear document of patient's intent. While clinics have the substantially high rate of decision focusing on the conscious dying patients in consultation with the physicians. So the background, yes. So this issue is about the naturalist, the hospice. The Minister of the Health and Welfare made a decision to apply national health insurance to hospice care services in order to expedite their expansion and the substantialization. However, it is characteristic in Korean societies. National health insurance and long-term care insurance operate in totally separate way for the sake of their transparency, which has resulted in the vulnerability of integrated care services for care receivers in civil societies. Hospice care service belongs typically to an integrated care service, but because of that, it continues to lean to palliative medical care even in hospice facilities. Yes, this act even designated the hospice institutions as a type of medical institutions. This regulation resulted in a policy of expanding hospice facilities initially and now focused in hospitals. Therefore, traditional hospice facilities associated with the religious organizations in a charitable base have faced difficulties. Moreover, the hospice care teams have been predominantly composed of healthcare professionals, including physicians, nurses, and medical social workers, limiting the participation of volunteers and spiritual care specialists to non-essential roles. In this way, the application of healthcare insurance has seemingly resulted in the distortion of the idea and philosophy of the hospice cares. And finally, it is a delivery system of high-cost hospice services. So, yeah. Oh. Yes, so is this, as in table 4, naturally, the Korean hospice facilities is stagnated even in period of Corona-19 backward in Korea. Part 4 is about the high suicide rate of young and old men and debate about the legalization of the assisted suicide. The attention to assisted suicide was sparked when the news of spread about the several Koreans registered in Dignitas in Switzerland, as in the Professor Kaycan. Particularly, assisted suicide as a dignified death has been raised by the Life-Sustaining Treatment Decision-Making Act, which triggered this discussion. This act still leads to the outcome of hastening the moment of death to some extent. In academia, this has been referred to passive euthanasia for dignified death, as well as active preparation for death, which allowed him to live out the remaining life more meaningful, as is noted by our that education site. However, the Korean media has broadly framed this within the context of Death with Dignity Act, which means assisted suicide in American legal context. So it is naturally that the question around about what to do if one is in a state of unbearable suffering that does not compromise even in minimal human dignity, or if one is not able to prepare for death in hospice facility due to such situation. Therefore, assisted suicide is an essential social issue that inevitably following the principle of dignified death. However, in Korean society's debate about the assisted suicide are inevitably associated with the fact that Korea ranks as the internationally in highest among OECD countries in terms of elderly suicide. As a result, the suicide rate of young is high and poverty rate among elderly is also high, with 26 suicide per 100,000 persons in Seoul, as this show internationally the notorious the index. The high elderly poverty rate is naturally came from the various issues related to the Korean society. So I think that in a country where over 17,000 elderly persons committed suicide only in 5 years, can assist suicide truly embody the value of dignified death? In 2022, medical experts and the elderly organization favor for the legislation argued for the expansion of the right to self-determination in death on the basis of 2 reasons. One is they have presented a public opinion survey stating the 76% of Korean citizens support the legalization of assisted suicide. However, there is a skeptic about what the national coverage approval rate of 76 means in Korean societies, where traditional taboos around death prevail and discussion about their own death and even death of parents within families are rarely held. Death education in Korean society is still not widely promoted, almost non-existent in school education, including universities. It is, in this sense, the overwhelming approval rate among young people and the middle ages of people who have rarely contemplated their own death is not seen as a meaningful public opinion. Yes, this table 5, initiated and designed by our aging center at Seoul National Universities, show the old ages opinion about the legalization of assisted suicide. Yes, less than half agreed on the legalization of the suicide, partly under the strict premise of the terminal situation and partly for protecting human freedom and autonomy. But this more than helps disagree on the legislation, partly due to the line easy with which life can be discarded and due to receiving hospice and palliative care as an alternative. Religious groups and academic groups concerned about the potential side effect of the promoting a culture that discards the value of life in our country with the highest elderly suicide rate. They actively argue that the alternative lies in the expansion and the substantialization of the hospice service. It is remembered that expansion of hospice facilities and substantialization of services have faced difficulties because of positive policies that they primarily focus on the expansion, acute medical care centered hospitals with a high cost. Second, of the restriction of life-sustaining treatment decision only to dying patients. paradoxically, the shortcoming of hospice services are being used as a basis for the legalization of assisted suicide. But it is noted that comprehensive, holistic hospice service encompasses not only the medical care using palliative measures to reduce physical pain and to alleviate symptoms, but also psychosocial and spiritual care, ensuring the physical pain do not lead to a loss of desire for life. Therefore, it can be considered premature to pursue the legalization of assisted suicide when the full implementation of the Life-Sustaining Treatment Decision Act has not even reached 5 years. Yes, we are attention in East Asian countries and outside the European and English. We more attention on the governmental pressure or governmental policies to right to die, good death. Although yes, I don't know the assisted suicide including. So I think that this Korean society is confronted with internationally rapid speed of aging and low fertilities even, will be super-aged societies and super-aged society. So in particularly, the advancement in biomedical technology and this integration of modern nuclear families, along with the dramatically rise in the single-person household, compel citizens to contemplate their own dignified dying and death at the end of life. Such considerations are no longer solely a personal matter, but it's social and governmental challenges. To realize the dignified life and death at the end of life, we should develop more elderly-friendly, ironically, innovation-friendly, or the sustainable social infrastructure. For example, is expansion of social safety net. For example, is the substantialization of end-of-life decision and hospice care in more sustainable way. Finally, it is noted a socio-cultural change do not for dignified dying and death, but also for more meaningful life at the 21st century is needed through the establishment of new, more innovative, meaningful educational culture, including death education. Thank you.
Thank you, Dr. Seo. Dr. Seo comprehensively addressed the current situation and the confronted problem of end-of-life care in Korean society, stressing the importance of the development of elderly-friendly system and death education. Is there any questions from floor? While waiting, I would like to ask you, as you know, in the current life-sustaining treatment decision-making law artificially divided the trajectory of death by terminal stage and last minute of their stay saying the dying process. So, and they recommend, the law recommended in a terminal stage shift to the hospice and palliative care. And the last minute and days of life can decide, the end of life care decision. So therefore, as you point out, the Korean life-sustaining treatment decision-making law is extremely restrictive. So it is difficult to achieve the purpose of respecting patient autonomy and implementing the patient's best interest as set forth in the law. So what do you think about eliminating the definition of a so-called patient in dying process in the law? Yeah. Would you use the microphone?
Crucial. Yes, in I think this in legally and normatively, the right to die, right to life is yes, it's very important, crucial for humankind. But yes, I am a sociologist who focus on the real situation, economic, cultural situation for protecting the rights of self-determination. I think that this in economically, European situation is not good for Korean and naturalist Korean societies. But it's even in Korean society, yes, more the sustainable way of protecting or the promoting the right of death with dignity and dying with dignity. What kind of policies is needed for that? I think that this various policies complex is needed. Sometimes cultural, including cultural policies, or the naturalist in the technical, yes, biomedical, technological as the policies, and others naturalists, including the various export. But is I am engaged with the civil movement for 웰다잉. Now as the president of the Death Education Association, Korea. But it's the cultural change is very, very important for protecting the autonomy, human autonomy and freedom in East Asian countries. It is shown in the Hayakawa CS Japanese movie of Plan 75, which raised the notorious, yes, best warning to government initiatives the cultures and these policies like the not just monsters of euthanasia.
I think you did not answer directly for my questions. I asked you whether do you agree to eliminate the definition of patient in dying process in the law and only leaving the definition of terminally for better respecting patient autonomy and the implementing best interest of the patient. Do you agree?
Yes, agree. Totally.
Okay, thank you.
I have the yes. Agree.
I forced you to say.
Moderate.
And is there any questions from floor? Oh, please, yes.
Hello. I'm Younsuch again from ASEM Global Acting Center. Thank you very much.
Speak up, please.
Can you? Oh, thank you. Thank you very much, Professor Sir, for your interesting and very insightful presentation. My questions are quite simple. My first question is, there are many criticisms or worries about legalizing assisted suicide in Korea. So I just wonder your opinion on what would be most dangerous consequences of legalizing suicide, assisted suicide, particularly in the context of Korea? That's my first question. My second question is, you said that you are leading the institution on 웰다잉 in Korea. So you mentioned the death education, importance of death education. So you didn't mention exactly what that education involves. Thank you.
Thank you. Yes, yes, now there is a strong debating about debating this assisted suicide. Yes, my opinion is premature. After the full implement of this life-sustaining treatment decision-making act will be done. So, if in the case of this legalization of the assisted death, hospice services is not the outside of the policy concerns. Now it's the similar situation, as I think that. Originally, this Minister of the Health and Welfare has had no concern about promoting hospice facilities and services in legalization of the act. So it's naturally assisted suicide will be considered as alternative to hospice services and naturally expansion of hospice services and facilities. Second is the legalization of assisted death can be lead to more growing of suicide. Yes, there is in Korean societies the many cases of lonely death in one-person family household, whether rich or poor. But this death is came from the suicide or dignified death. I don't know. Yes, I don't know. But it's this complex situation is now. So highest the rate of elderly suicide rate in Korean societies came from various regions, including naturally the assisted death at euthanasia or the insufficient treatment. So as I think that these two regions, the by effect, of legalization of the suicide. Second is cultural change is very, very important for protecting the human freedom of the self-determination right in Korean, partly the collective societies, and like the Japanese societies. But it's the government want to now sustain in welfare systems in the sustainable way. This desire, this intent is including the legalization of assisted death and self-life-sustaining treatment decision making. So as we want to develop the social cultural change for protecting self-determination, right to die, and etc. through the death education, expansion of this education, naturally in school education and in the elderly family facilities, and even in hospitals. Naturally, so the education is a tool for developing this more the elderly friendly cultures and etc. in long terms, not short terms. But it's, in Korean societies, there's a low level of test education, which is not yet in school education, not in naturalist, including the university education. Yes.
Thank you. Let me move the last presentation. The last speaker is Dr. Atsushi Asai at Tohoku University Graduate School of Medicine in Japan. Dr. Asai will talk on voluntary assisted dying in present-day Japan. Please.
Thank you, Chair. I will share my slide.
Yeah, we can see.
Okay, thank you. Yeah. Okay, so first, thank you very much for inviting me such a precious opportunities. And I understand that I'm supposed to talk about current situation of Japan regarding voluntary assisted dying. Outline of my presentation is as follows. Because of limitation of time, I will talk about introduction, 3 cases happening recently in Japan, and as third, views of opposing voluntary assisted dying in response to those cases. Then I will go to the conclusion. First, assisted suicide and commissioned murder, including active euthanasia, are illegal under our country. No laws or official guidelines govern medical assistance for dying in our country. However, over the past several years in Japan, cases of assisted suicide or voluntary euthanasia have occurred. Inspired by those events, various debates arise in Japan, as it has been in many other countries. It is important to discuss voluntary assisted dying, VAD, cases in Japan, and the Japanese view against them, and to consider the implication. We review recent Japanese VAD and discuss the various objections to VADs that have been published in many responses to those cases. So first, I would like to talk a little bit about 3 cases. First, Ms. K. In November 2018, K, 51-year-old woman affected by multiple system atrophy, ASA, died by suicide with assistance of Swiss-assisted suicide organization Life Circle. Her 2 sisters accompanied her and were presented by her side. When she was in her mid-40s, she became aware of tangle in her leg, and then at the age of 48, she was diagnosed with ASA and stopped living alone and began to live with her eldest sisters and their family, her family. She felt pain in her legs and arms. When the disease progressed, she was told that she was likely to become bedridden and dependent on both gastric tube and ventilators. her sisters cared for her and changed her diapers. She wanted to end her life before she became bedridden. In March 2018, she made multiple attempts to die by suicide, either by hanging herself or by partaking in drug overdose. In August, she registered with Life Cycle, and in November, she was informed that assisted suicide could take place on that month. She arrived in Switzerland with her two sisters on 25th that month. After completing certain formalities, she died suicide through an intravenous drip of lethal drug on 28th November. And before I go on, I would like to add my explanation. In this paper, voluntary assisted dying, VAD, is defined as practice including all forms of assisted suicide in general, physician-assisted suicide, and active euthanasia administered by physicians. Okay, let me go to the second case. The same year, January, the drowned body of N, a 78-year-old man, was found. He was nationally very famous critic in politics and had previously stated in several of his books that he was determined to die by himself, and indicated that he refused to die in a hospital because he did not want to, others to dictate or play around with the end of his life. He had told everyone around him of his intention to die by suicide. He had been widowed for several years, had a painful spinal condition and severe skin disease and neuralgia in his right hand, which he prevented him from writing. In April, two of his acquaintances up to 20 years were arrested by the Metropolitan Police for assisting him in his suicide. He was unable to die alone because of his physical conditions, but the scene of suicide led to suspicion that he had been assisted by others to die by suicide. 10 days before his death, N had said in a TV program that real blessing for human being is to be able to die. N said that in one of his books that human life is always a process involving constant choice. In the final stage of this process, the choice of how to die awaits us, and that the way we die wrap up of the way we live. Final case is about active euthanasia, voluntary active euthanasia. At the end of November 2019, two doctors euthanized a woman aged 51 years old named H at her request at her house in Japan. She had a myotrophic lateral sclerosis, ALS. The doctor were arrested in July on charge of commissioned murder. H and the two doctors did not know each other. The doctor received 1.3 million yen from her. She was diagnosed with ALS in around 2011. She was bedridden at the time of her death and decided not to have a tracheostomy. And she received artificial nutrition through a gastric tube and required care every day, every time, all days. She was unable to speak and used visual input to express her wishes, but this became increasingly difficult as her eyesight began to deteriorate. She considered opting for assisted suicide in Switzerland. However, this was no longer possible as her physical condition had deteriorated. But her desire to die was so strong that in that year, after pleading on social media for help, so she could be euthanized, and she contacted the doctors mentioned above and asked them to euthanize her. Her father did not know that she was communicating with the physicians on social media. So those are the three cases happened in the past several years in Japan, and it had a tremendous coverage in the mass media. And there are many opinions about that, mainly objections to their activities or the doctor's actions. So I will introduce, I will refer to the 10 main major objections and to BAD happened in Japan. Of course, there are common objections to voluntary euthanasia or assisted suicide, such as sanctity of life or killing with wrong. They are the same to the, I think, other many countries, but here I have chosen to, objection which is, culturally more Japanese-like attitude. I'm not sure, but anyway, first one is this is not just a personal event, sorry, for the person who opted for BAD. It means that, our life is shared by others. For example, for families, so we cannot decide our life alone. So this is not the object of self-determination. And this is a very common, one of the common objection to individuals' BADs. Second objection is that a person's hope for BAD, I mean dying, is changeable and authentic. One philosopher declared that everyone who want to be killed or die is actually crying for help, not want to die, just want to help. So, and when diagnosed of the very serious disease, they had a shock and have a very acute hope for death. But as time goes by, their wish to die disappeared. That's his opinion. Okay. Third one is a person wish to opt for VAD out of concern for others. It means that it is argued that some person want to die to avoid being a burden to others, burden to families. And in our countries, sontag or surmise, it's an attempt to read others' mind. Is very common, and some people believe that they give too much burden to others, so feel I have to die, that kind of things. Fourth one is that people opt for VAD as a result of peer pressure, owing to a discriminatory atmosphere. We called it cookie or air. There is nothing. There is no actual physical pressures, but just we feel some kind of pressures, people around us. For example, even now, many people are wearing a mask, even outside of the building. Yeah, it happened. So it's kind of the atmosphere. Yes. Fifth one is empathy. This is especially physician empathy lead to the person to die. It means that doctors find patient situation is terrible, unbearable. So they are willing to help to their death. That kind of doctor's attitude, and it is criticized as discriminatory, but that causes a person to die. The number 6 is voluntary assisted dying legislation aimed at reducing national healthcare costs. I believe this objection is not limited to our countries, but many commentators in other countries say this one. Well, I think that if the real intention to legalization is to reduce national health cost, then it is not acceptable from the ethical point of view. But I'm not sure. I think that several government or states have legalization because they want to respect patient self-determinations. So I don't think this objection is right or not. Sixth one is it is premature to aim for registration on BAD in Japan society. So they say that before discussing a BAD, we have to make our palliative care, our welfare for the poor, and we have make perfect. Then we have to correct that very bad situation for the disabled people. So we cannot start the discussion about BAD before we resolve those many kind of social problems. So patient who want to die had to wait. All difficult problem resolved. Next one is BAD endorse eugenics and pose a risk to vulnerable group, disabled, sick, elderly, poor, oppressive, and other minorities. So it means that BAD registration were the agreement to the voluntary assisted dying pose a risk to the vulnerable peoples. Well, this is one of the typical example of slippery slope argument using euthanasia by Nazi regime 80 years ago. I'm not sure this kind of slippery slope argument is possible. I don't know. Ninth is a case mentioned about Push people who are suffering from disease or disability to suicide. So this objection is mainly that suicide is infectious, suicide is contagious. So, and there is a small evidence about that. Several years ago, one of very famous patient with brain tumor in the United States had a assisted suicide in Oregon State. Then several people followed her. So it could happen, but I'm not sure how many people had a very big impact. And I also believe that there should be the other strategies to keep those people from doing suicide if they don't have a due process. The final one is that the two cases who assisted age to die were not her attending physician. So this objection implies that we need strong physician-patient relationship, and without that, BAD should not be done. But I'm not sure that this kind of private, long-standing doctor-patient relationship is an essential condition for BADs. Instead of that, we may have a formal process to check the process is going safe, and abuse will be avoided. And discussion, we believe that all of these views had points that needed to be systematically addressed if the BAD procedure is to be incorporated into Japanese social and legal system from a practical point of view. However, to argue for the ethical permissibilities of BAD from standpoint that voluntary, independent, and authentic decision-making of free individual is more important than other values, as well as from the philosophical standpoint, we can challenge some of the objections above and point out the problem inherent in them. And as I said at the beginning, some of those objections can be considered alarming psycho, cultural, and social issues of Japanese society today. So I will not going to discuss each of objections, but I believe that we can refute those 10 objections using discussions such as double suffering of the individuals, individuality of death, variability of culture, a problem of being an annoyance to burden on others, and slippery slope in the opposite direction, and responsibilities imposed on the wrong parties. I mean, very wrong responsibilities imposed on the patient who are suffering. So my conclusion is that what comes to mind, our mind first on running those three cases of K and H was that they could have died differently, more honestly, better, at least with dignity, if they had been resident of Switzerland, Canada, Belgium, or Netherlands, or now Canada, Victoria, Australia. The fear of those opposed assisted dying should be rigorously addressed by safeguarding legislative system governing voluntary assisted dying, while also transforming Japan into a society in which individuals who want DAD are provided with it through due process. So it is necessary for us to carefully consider the acceptability of DAD for our society now. So that's it for my presentation. Thank you very much.
Thank you, Dr. Asai. Thank you to limiting your discussion by time limit. I recommend the audience read his slide in the brochure. He quite well addressed the why assisted death is difficult to be accepted in Japan. Truly, Korea is the very similar situation. Is there any questions from floor? Dr. Asai, are there any, the formative legal guideline for end-of-life care decision in medical institution in Japan?
You mean legislation?
Legal guidance.
Yeah. Yes, we have a guideline published by the government about process of decision-making at the end of life. But it's about just process, the process of discussions, but not any substantial content in it. Just process.
Yeah. Any questions? Yes, please.
Hello. Hello again.
Hello.
Yeah, hello. Thank you very much for your excellent presentation. It's really interesting to learn about Japanese case, which is very similar to Korea's. And my question is, I have broadly two questions. One is, you mentioned that Canada or other countries that adopted or legalized assisted suicide as a way, as a kind of model for Japan or other countries to follow. But as far as I understand, there are many problems, especially in Canada. I read papers about the after adopting, the legalizing assisted suicide in Canada. Actually, in fact, this drove many poor older people to kill themselves. So I just wonder whether you are actually aware of these problems, or whether there would be some measures that should be in place to prevent such dire outcomes after adopting or legalizing assisted suicide. That is my first question. The second question is, of course, we can talk about the the assisted suicide at the academic level, from specialist perspective, but I just wonder whether there is such a survey on the public level, how ordinary Japanese people see or perceive the accept or legalizing committed the assisted suicide, whether there is agreement on that, or is there resistance to that? So I just wonder there is such a survey, and what are the reception of Japanese public? Thank you.
Thank you very much for your questions. For the first one, I actually know that various practical problems involved in the registrations in Canada or Australia. Actually, when I wrote my recent papers, I checked. In the process of discussion with reviewers, I found that there are lots of problems in the process of BAD in Australia. So, so my main point of today is that human dignity or autonomy is very important. But as I wrote in my paper, at the same time, it is very important to address the problem what you mentioned, that poor old people are likely to die. That kind of situation have to be prevented. So as I wrote in my paper, that suicide because of poverty or because of old age or that kind of problem should be addressed by society as a whole, although it is very difficult. Yes, so this is my answer for the first question. Second question is, I'm not sure about the, attitude toward legislation of euthanasia of assisted suicide, but 2 or 3 years ago, there was one very big national surveys, and in that surveys, 18%, 1 out of 5 people surveyed agree with the voluntary assisted dying at the end of life, I think. And in the past 20 or 30 years, there are several national polls about euthanasia. The number is very diverse among 5% to 25%. So in general, I don't think majority of people are willing to accept registration via this, but there is no recent direct question in this regard. So I'm not sure at this moment about that. Thank you.
Thank you, Dr. Asai. We have come to the end of our session. As discussed, as discussed in this session on dying with dignity, we found that there is a large gap in the level of respect of patient self-determination and the social awareness of unbearable suffering in Korea and Japan compared with the many European countries. I think nevertheless, a social consensus on the right to death for incurable patients with unbearable suffering becomes an important task to the countries that do not allow assisted death. Specifically in Korea, I think that it is very urgent to extend the limited patient right to decline any unwanted medical care to the terminal stage rather than the dying process defined by current act on life-sustaining treatment decision-making law. Lastly, I would like to thank all of the speakers and all of those who joined to make this session meaningful. Thank you very much.
Thank you very much for your participation, our speakers and moderator. Please give them a big hand again, please. Thank you. Thanks to their meaningful presentations, we were able to think about the definition of right to die with dignity, and we had a chance to compare the perspectives on voluntary assisted suicide between European countries, Japan, and Korea. Thank you very much. All right, now we're going to have a break for 30 minutes, and coffee and refreshments are ready at the lobby. Please enjoy your break, and we'll see you here at 4 p.m. Thank you.